Okay, we're gonna get started. Thanks everyone for coming here tonight. My name is Evan Epstein. I'm the Executive Director of the Rock Center for Corporate Governance. For those of you who don't know, the Rock Center is a joint center between the law school and the business school, and we focus on corporate governance. We host many events, many programs. We do a lot of research, and we're very happy to have this panel here today about critical risks facing technology companies in 2013. And it is great to have practitioners and regulators here. Normally we have a lot of faculty, we have a lot of research, but this time it's going to be a vision from practitioners. Part of the objective of the Rock Center is to put together practitioners, regulators, and academics to discuss governance, and I think this is what we're looking at today. Again, I think it's going to be a very interesting discussion. We have topics such as FCPA, Dodd-Frank, whistleblower provisions, insider trading, general compliance and investigative risks, data security breach risk. There's a lot of things that they're going to cover in this panel, so I thank you again for coming. This is going to be a taped presentation, so it's going to be online in our site later on, but I think we should take as well time to ask the tough questions now and the interesting questions, and I think you'll all enjoy. So thanks again. Christine.
Can everyone hear me clearly? My name is Christine Belliveau. I'm with FTI Consulting. I'm a senior managing director, and I'm a forensic accountant. I'm someone that Sharon might call when she has a problem that Sam or Andrew have called her about, and then we might all go and present the results of what we learned to Tracy. So that's how how we all interact with each other. Just to give you a little bit of background on our panel members today, Sam serves as a Director of Investigations, Office of Legal Compliance with Microsoft. So she's flown down from Seattle to join us here today. Her team is responsible for managing business conduct compliance investigations across the globe and reporting on investigation issues and trends to the Audit Committee and Board of Directors. Tracy, who is on the far left side, is with the SEC, the San Francisco Regional Office. She's the Assistant Regional Director in the Division of Enforcement, has been with them since 2002, and specializes in the Foreign Corrupt Practices Act unit. Andrew, who is to the right of Tracy, is the lead investigations counsel for Google's Global Ethics and Compliance team. The team's core mission is to lead the company's efforts to identify, mitigate compliance risk, and to nurture and expand upon the company's core value of don't be evil. I love it. In his role as lead investigations counsel, he's responsible for conducting and managing investigations into alleged code of conduct violations by company employees. And then lastly, Sharon, who is directly to my left, is a partner with O'Melveny & Myers' San Francisco office. She specializes in white-collar defense and corporate investigations group. She served as an assistant U.S. attorney in the Northern District of California from '99 to 2005. So this is going to be an informal kind of interaction. We have obviously a list of subjects that we want to cover, and I'll put some questions to each of the panel members, but we also invite you to ask questions if you'd like as you go along, or if you want to keep them towards the end of the session. We'll make sure that we have some time for questions. So the first subject that we wanted to touch upon is M&A and global business risks. So there's been a lot of news lately that you've all seen, I'm sure, about the risks associated with making acquisitions in foreign companies. The first one is Caterpillar, who acquired a company in China, and a year after their investigation, they had to write down the majority of the purchase price. Our second example, which is really relevant to our current location or geography, is HP's acquisition of Autonomy. There was also a significant write-down, a great percentage of what they purchased or what they paid for the company. So my first question I'm going to put is to Sharon, and to ask, what steps can companies take when doing their due diligence to try to avoid these types of issues?
So foreign acquisitions obviously present huge potential risks for the acquiring company, both with respect to valuation and accounting issues that might come back to haunt the company later after the acquisition, as was the case in the examples that Christine mentioned, and also with respect to other compliance enforcement problems like FCPA, money laundering, export controls, and the like. So I think in thinking about the steps that a company can take in embarking on this very hazardous adventure, you got to break it down into pre-acquisition steps, due diligence steps, and then potentially post-acquisition steps that can be taken. The first comes before due diligence, and that's when you're structuring the deal itself. You've got to negotiate, companies have to negotiate into their agreements the ability to conduct the level of due diligence that's going to be required given the risks in the foreign jurisdiction or with respect to the company itself. I've definitely seen deals where that was not written into the transaction documents, and it limited down the line what could be done. So this means building in the opportunity to review books and records, building in the opportunity to interview management and third parties. You also have to build in time to conduct an appropriate due diligence and have a due diligence plan and consider how you're going to execute on it, given the time pressures that are involved realistically in an acquisition. Also, before you even get to the due diligence, you have to negotiate in a transaction a proper exit strategy if issues are found during due diligence, or at least a way to factor into the value of a transaction the costs of whatever it is you find during due diligence. So all of that might be very difficult depending on the nature of an acquisition. You might have external timing pressures. A company might have external timing pressures. There might be competition for a particular target. You might not feel like you have the negotiation power to do that. But it's worse in the competitive landscape to buy yourself into a felony. So those things are important in the negotiation stage. With respect to due diligence for foreign acquisitions, it's very important to have local counsel or counsel familiar with the local jurisdiction where the target company is. There are very common pitfalls for these acquisitions related to privacy issues, related to data issues in the foreign countries. Local experts can also give insights that outsiders might not have, and obviously overcome language and cultural issues as well that can prevent compliance issues from being uncovered in these acquisitions. So you need the local expertise, but you also need to understand that ultimately it's the U.S. regulators and the U.S. law that will likely cause issues for you down the line. So you need a U.S. presence, a U.S. oversight in the due diligence process. I think the examples that you mentioned and many others that have been in the news have shown that in the due diligence phase you can't rely on even audited financials anymore. You need to companies need to engage outside auditors, outside lawyers, outside bankers. And do kind of a double check even when the target company is presenting them with audited financials. Even then, you can't rely on the paper that is prepared. Due diligence is not a paper exercise. I like to say that you can't really conduct a smell test unless you're there to smell things. So you've got to be on the ground, you've got to meet people, you've got to do inspections, you've got to do inventories and speak to customers and suppliers and actually go there. And this is something companies are in the best position to do rather than their experts in certain situations, because a company will know the business and a company will know what a business is supposed to be like and can make those assessments on the ground. A couple other issues in due diligence, especially with respect to accounting issues. Make sure everyone's speaking the same language. Make sure you know whether the target's auditors and accountants are applying U.S. GAAP. And if they're not, what standards have been applied? Everyone has to speak the same language, both kind of literally and figuratively when it comes to these issues. And then I think the most important thing that companies miss is not heeding the red flags that come up during due diligence. Companies can't drink their own Kool-Aid when it comes to the acquisition fever. There has to be a reporting structure for the due diligence process so that those who are on the ground and might be the recipients of the red flags know how to report that up and are forced to report that up. So that those with a more objective sense can follow up on those red flags. Things like, are the purported earnings way out of line with the industry? Have there been changes in management, changes in auditors that are unusual? Pretty common red flags that get missed can just lead to troubles down the line. And then, so that's due diligence, and then after the due diligence, either before or right after the acquisition, there are some steps to be taken. Companies need to have a well thought out accounting integration plan for the company they are acquiring, and also a compliance and training integration plan, so that they can bring the acquired company into their compliance structure. Remedial actions can be taken immediately following the due diligence, some by the target company itself before the acquisition. So if misconduct is found during due diligence, obviously the misconduct needs to be stopped, employees can be disciplined, and the problem can be remediated. And then at that point, obviously the acquiring company can consider whether to disclose what they've found during due diligence to the SEC or to the Department of Justice, which is a topic we'll get into, I'm sure, as we go down the line.
So Sharon touched upon some of the transition items that you should address once you've closed the deal, you've done your due diligence, and you've decided to go ahead with it. Andrew, do you have any other recommendations or best practices on how to kind of transition in a U.S. compliance or U.S. corporate policies into a newly acquired company?
Yeah, so I think one critical piece is understanding what are the major compliance risks that the foreign company presents to the acquiring company. Sharon touched on them: corruption risks, any money laundering, export control issues. One compliance risks that faces a number of technology companies is data security and privacy. It's something that's really significant to our company, Google, and we take a number of steps to achieve compliance and achieve some type of consistency with our own internal policies and implement our internal policies with the company that we're acquiring. A critical step in doing that is understanding the foreign company's systems, understanding what data these companies hold. What do they do with employee data? What do they do with corporate data? What do they do with user data? How do they protect it? Who has access? What type of controls are in place? Understanding the acquired company's relationships with third parties that have access to user data, access to corporate data, payroll data, employee data. The way you do that is by interviewing, and you got to talk to people at the companies that you're acquiring. Talk to the data owners, understand the systems, understand the controls, and then you put in a training program. How it is that we protect our data, how it is that we limit access to our data, how we control our data is the same way that the acquired company is going to have to do it. So it's a major training component, education component. And then there's the discipline. If there is non-compliance with our internal policies, we have to set up the appropriate incentives for our acquired company to make sure that they're following our internal guidelines as we've placed here in Mountain View. So I think in terms of achieving compliance, it's education, it's training, and then most critically, understanding the environment at the acquired company.
That's good. So if a problem does come up, Sam, what should the company do?
Well, I think the first thing that a company needs to remember if you have a post-acquisition problem that arises is you need to recognize that, your obligations are unchanged. There's no, but that was before we were married type of defense, right? You need to, recognize that you're, regardless of the corporate structure, the chances are very good that you'll be held, responsible. You'll have some level of liability for what you've discovered or, what you may be looking at. So it's good to keep that in mind. To Sharon's point about, if you're talking about an acquisition of a foreign company, I'd echo her advice that you retain local counsel. You're going to want to know what rights, apply in that jurisdiction for, the complainant. If there was a complainant or whistleblower in that situation, one of the first things I'd want to know is what are the rights of that individual, and then I think that the company should, protect those rights and possibly exceed them if they can, consistent with its own company culture and values. So that's something to address right away. You're going to want to know, you're going to need to understand with an understanding of what that corporate structure is and what your rights are, and then proceed to do your typical, investigation and assume that you have perfect and total rights to look into absolutely everything that you need to, and don't be, deterred by any kind of, barriers that may presume to exist because of the structural differences. That would be important. And at the same time, I'd also want to know and have some understanding about what are the company's rights. This wouldn't necessarily fall within my role if I'm responsible for the investigation, but I think the company's going to need to know whether it has any rights vis-a-vis the acquired company or its executives. And if they are your executives now, that goes to my, the overarching obligation and liability. And it's good to remember that, it's not enough to kind of bring them in and sit them down and say, okay, well, you may have done that back at your old company, but, here we do things differently. We don't tolerate that. That's probably not going to be enough when you consider that the DOJ and the SEC are going to look at your compliance program overall, and they're going to assess whether you have a company culture that enforces, the right kinds of things and permitting, what may have been, wrongful conduct or even felonious conduct just because it happened before you had anything to do with them. Letting those people continue to serve in your company is not going to advance your own company's compliance interests or your reputation. So that's the approach I think, that would be wise to take.
So Tracy, Sam was talking about, what happened prior to the marriage isn't relevant. Is that in line with what the SEC, or is still relevant, and the acquirer is kind of accountable for that? Is that in line with the SEC's perspectives?
Well, first, let me say, because I work for a federal government agency, the remarks that I make today are my own and do not reflect the views or the positions of the SEC or its staff. So with that, I would just say that with respect to acquisitions, it really depends on the facts of the situation. It depends on, for example, Sharon mentioned red flags and whether red flags were known during the due diligence process. So once we get into a situation where we're investigating a matter, one of the things we'll look at is how much did the acquiring company know? Were there red flags? Did the conduct continue, and for how long did it continue after the acquisition? So sometimes you'll have a situation where prior to the acquisition, information comes up, red flags come up during the course of due diligence, and either it doesn't rise to the level of someone who has the ability to respond to it, or it does rise to that level, but nothing is done to stop the conduct from continuing once the acquisition is completed. So it really depends on the facts in terms of whether the acquiring company is liable for the conduct, and those are just facts that we have to consider during the course of our investigation.
So some companies choose, instead of acquiring a company, to enter into kind of a business relationship or partner with a company or hire a third-party company to do business, either to do R&D for them or to do manufacturing for them. sales, customer support in a foreign country. So what types of additional procedures need to be performed, or different types of procedures need to be performed maybe in that type of relationship? Sam?
You know, I would be speaking more to, you know, kind of the overall compliance risks and of looking at what kind of compliance risks you might face. But the fact is that, you know, having that kind of relationship is, you know, there are huge risks attendant to that. And they don't all fall neatly into, for instance, my area of practice, which would be, you know, compliance, business conduct compliance issues, but there are a whole host of, you know, risks that are presented to the company in terms of, you know, environmental practices, what are the labor policies of the business partner, what are their safety practices. So you really need to look into a lot of those issues when you're engaging in a business relationship, and really give some thought to how that business relationship will affect your own company's reputation and your, because there's a lot of reputational harm that can occur if you do practice with companies that don't share or adhere to the company values that is, you know, your company's biggest asset that you've worked really hard to develop. So, you know, you want to look, of course, at the key risks, and you want to do significant vetting before you enter into that relationship. And I know we're going to talk about vetting in more detail soon, but that's really, you know, going to be especially important, and it should cover a wide range of risks and disciplines, not just, you know, as I mentioned, the key, you know, what are the accounting, you know, the accounting records in order? Do we have the audited financials? Do we have all those things? All of which you might want to look at almost to the same degree of scrutiny that you might give to a company that you're acquiring. It's become that important. But, you know, despite these risks, there's no question that, you know, these kind of relationships are absolutely necessary. There's no way that one, you know, corporation, even one as big as Google or Microsoft, is going to be able to serve, you know, get its goods and its services into, you know, the all across the globe without entering into these kind of relationships. So as the work and the business model and the services diversify and get more complex, it's absolutely going to be a key way of doing business, you know, going forward. So it's something we're going to have to incorporate and build into our, you know, our thinking about compliance.
So one of the things we've seen is companies might, as part of their arrangement with the business partner, require the right to do audits, right, or to come in and review certain aspects of their business. Is that right, something that you feel is helpful?
Oh yeah, absolutely. I mean, you know, that should be a key, you know, and absolutely required non-negotiable element, you know, similar to the kinds of things that Sharon was talking about. You would build into your deal structure, you would build in those audit rights, you would also build in the ability to terminate the relationship with very little notice, and really it's almost an at-will, you know, termination is the standard that you would want to achieve. You know, there may be some business costs associated sometimes with doing that, but those are some kind of key elements you would want to build into your contract, you know, your arrangements with the firms and the other companies. And that would be really important in a whole host of areas. You'd want to audit not just their financial records, but also, you know, some of their other practices as well. I know that as our company has, you know, gotten more into the, you know, hardware supply business, which it traditionally hasn't been involved in, that's something that we as a company are paying a lot of attention to and learning a lot more about how you deal with those risks in a global supply chain in a different way in the context of hardware, which you move across borders, which you manufacture. There are a whole different set of issues that come along with that shift in the business model.
So what I've seen is a lot of time companies will only go in and do the audit when there's a red flag. Is that kind of a best practice, or should it be kind of more of a regular recurring type of procedure that's done maybe on some level, some frequency of per year or every couple of years?
Right. You can build in regular audits, you can build in regular testing, site visit requirements, and you also can require kind of certification by your partners. A lot of companies have turned to some partner certification. The other thing that that I think a lot of corporations are turning toward now is We also can require that you sign and adhere to our code of conduct, that you agree that if you're going to do business with us, that you and people that you employ, and maybe even your vendors, are going to be held responsible for knowing and complying with the codes of conduct that the own corporation adheres to.
So if a problem or a red flag does come up, Sharon, what do you recommend the company does in that situation when it's a business partner versus a company that they own?
Well, I mean, depending on the relationship, you're still going to be, and how you handle the red flag, it's still going to come back to you, come back to your company. Again, depending on how the relationship is structured. So that means you heed the red flag and you conduct an investigation. A big issue comes in as to how that investigation is conducted. It's not the same kind of thing where you're doing an internal investigation of internal misconduct, but here you have this business partner, and the red flag is about their misconduct. So structuring that kind of investigation is a little bit different than you would structure an internal investigation, for example, where you have a lot of questions that might come up about the integrity of the investigation. So with an internal investigation, you ask a lot of questions about who conducts the investigation, whether it can be done inside the company, whether it should be done outside the company. The questions are not so much the same with respect to business partners, although there are certainly things in the business partner relationship that can affect the integrity of an investigation and may warrant bringing in outside folks to do the investigation. Again, it depends on the relationship that there is with that third party. But there are a lot of practical issues to consider with respect to how you conduct an investigation of a business partner and whether you use your internal resources or external resources. Companies are, obviously very concerned about cost effectiveness and efficiency in an investigation like that. You have big companies who have these types of relationships all over the world with many, many business partners. So it's not like they can be expending tremendous resources all the time over and over again. So cost effectiveness and efficiency are very important. Usually that means, a first reaction might be, well, that means we need to do it in-house because, it'll be more cost effective. That way we won't need to hire a lawyer. They're very expensive. That's sometimes true. It's sometimes not true. There are obviously, when a law firm has done the same investigation many, many times, there are efficiencies that come into play there. The other thing to consider when you're structuring an investigation of a business partner is that this is a business relationship. And, assuming all goes well, it will be a business relationship on into the future as well. And so conducting an investigation of your own business partner can lead to business conflicts down the line. So having a third party, an outside party, a law firm come in to do those types of investigations sometimes, can smooth things over down the line. There are also, benefits down the road if you do end up having to deal with a regulator on an issue related to a business partner. I think there are benefits from having brought in someone from the outside to conduct an investigation in some circumstances. And then there are also privilege issues that can arise in these types of investigations. So when you have in-house counsel, for example, conducting an investigation, there will be questions about whether the privilege applies to an in-house counsel who's kind of wearing both a business hat and a legal hat. So again, just kind of issues to consider in conducting those investigations.
So we talked about all these foreign companies, and we kind of tiptoed around FCPA, but we really didn't get into it. So obviously you can't talk about doing business in foreign countries without discussing FCPA, so we'll get into that a little bit further now. And we were wondering if Tracy maybe could give us a little bit of a high-level view of what is going on with regards to FCPA.
So high level, still a specialized unit at the SEC. So clearly the Division of Enforcement believes that it's a specialized area that warrants the dedication of resources and the focusing of our resources in that area. There's no shortage of work in the FCPA unit, of course, with the globalization of our economy. and companies, multinational companies. The SEC and the FCPA unit are busy. There have been some areas, the pharma area, oil and gas, that we have sort of focused on, but those areas really come out of cases and trends that we find out of cases. Basically, in the context of our investigations, once we start seeing trends in particular subject matter areas, we start noticing the need to sort of focus our resources. So, for example, with the pharma area, if we see that there are a number of companies that seem to have the same kind of issue, or if we see companies that use the same kind of third-party agent, then we will talk within the unit about whether people are seeing the same trend, and that's really the reason for having a specialized unit. It gives us the ability to do that. So in terms of what's going on, still very busy. Still a lot of work in the FCPA area.
So far, the tech company seems to have been kind of, as an industry, not too affected by FCPA. Sharon, do you think this is going to stay that way, or do you expect that there'll be maybe an uptick?
I mean, I think that the tech industry is definitely, a ripe area for FCPA enforcement. Not that I want to give Tracy any ideas for any of my clients, but or for anybody at the table. But I think that just given obviously the region that we're in and the nature of technology businesses, generally that they rely on and do business with foreign entities. For manufacturing and fab, for distribution, and the like, they do business in countries where there is a serious risk of corruption. And whenever you produce or sell or do business in those countries, it doesn't matter that you're not doing business directly with a foreign government, which is what some people tend to think of when they think of the FCPA. If you're doing business with any company that is regulated by a foreign government, that's where I think the even larger FCPA risk comes in. So, your technology companies, that have a manufacturing plant in China, they have environmental regulations, they have labor, power, tax, immigration, technology licensing, all of those regulatory aspects of a foreign business give touch points with foreign governments and an opportunity for corruption and a very high risk for improper payments. So, I think that the technology industry is arguably analogous to some industries that have had kind of an industry-wide push, like the film industry in Southern California. There's not so much that differentiates the film industry maybe from technology companies. So, we haven't seen an industry-wide, I mean, on this level, on the FCPA
I would like
level.
to hear that metaphor.
I could play that out a little bit. So we haven't seen an industry-wide push, but I definitely think enforcement will continue, and I think, frankly, as M&A activity increases now that the economy is getting better, I think there's going to be more and more opportunities there for tech companies to get into trouble in this area.
So the SEC and the DOJ put out some guidance. It's called the Resource Guide to the U.S. Foreign Corrupt Practices Act. It was published in November 2012, and it's really an extensive list of guidance and recommendations, kind of pulling together a lot of different pieces that were existing in various different areas. But one of the main themes is that a robust corporate compliance program can help prevent prosecutions, or that could allow companies to get more favorable results when they do identify foreign corrupt issues within their companies. But some of the complaints, I guess, from the Department of Justice has been that though these companies have these compliance programs, that there's no muscle behind the programs. So Sam and Sharon and Andrew, and then Tracy, I'd love to hear your thoughts on this too, is, what are examples of muscle that, should exist that maybe not all companies are really putting into their programs, something that's, kind of concrete?
All right, well, I think for a while, companies have been, really observant and reading a lot about the guidelines for an effective, in the sentencing guidelines, and trying to glean everything that they could from that. So I think there were some really early and kind of obvious lessons that people and corporations took from that, which are, make sure your compliance program is well-resourced. And there was a rush within probably, maybe the last 10 years to create these entities and these programs, and to, staff them up and get people to, come in and dedicate themselves to that function of compliance. So that was a good step. There was another, a lot of thought given to how you build in some structural or maybe, or functional independence into that role. How do you kind of make sure that the compliance function within your, corporation is in a position, has the authority that it needs, is in a position to report effectively any issues that might arise to the audit committee of the board of directors. Those are things that kind of corporations did early on. I think we've been growing in our sophistication and application of concepts like self-assessment. I think that's a really important one, and the DOJ guidance emphasized that as well. That self-assessment is very important, that should happen on an ongoing basis. You should assess your program. There are a lot of ways to do that. You should have a combination probably of self-assessment and periodically get some independent objective assessments of your program as well. And then have built in also a constant overlay of auditing, testing your programs and your controls. So those are all kind of the obvious elements that I think people have incorporated and been working on. And they're getting better all the time. They're growing in sophistication, and as the kind of field develops and matures, those things are getting more embedded into the corporate culture, has been my observation. But I think it's the corporations who are really want to put gold standard programs together, are also kind of taking things to the next level. And I think that there are some other things that, Microsoft certainly has paid a lot of attention and effort toward, and I know other corporations have as well. And those are really thinking about things like, prevention. I mean, for instance, I manage our global investigations team, but I can tell you that I don't just sit around and investigate or review investigations or direct investigations all day. I spend a significant part of my time, thinking about prevention, trying to work with the other programs and the other teams within the compliance structure and throughout the company on, how do we take what we've learned from our investigations, how do we apply those learnings in the field, how do we incorporate thinking about compliance into kind of upstream business planning throughout the company. That's kind of a next level of sophistication and saturation of the compliance effort and accountability effort, within the company. So I think there'll be a lot of, I think that there should be maybe a lot of scrutiny and attention to that aspect of what compliance programs are trying to do. And another one I think that we've been working toward, and this one's difficult, is that I think that corporations and compliance programs are beginning to think a little more thoughtfully and maybe with a longer term view when you think about transparency about what you're doing within your company on compliance. I think that in the past there has been a fairly conventional wisdom that people often applied to things like, we're doing this investigation and we're disciplining someone. There were a lot of employee privacy issues that tended to dominate that conversation about what information was shared, about that matter and about that investigation. I think that's beginning to change as people begin to see, look, there's really a lot of deterrent value in sharing information and showing and demonstrating within your own company that these things are detected, that they're investigated, and that there's results and enforcement that comes out of them. So that's one aspect of the transparency. Also, when you think about sharing information even within the company, from one business division to another, from one region to another, that's something that corporations are beginning to take a different look at. That certainly I think lawyers are no stranger to paranoia, and I think that that has driven in the past a lot of the the kind of thinking about, it's all about compartmentalization. Certainly that's an element of what we have to think about when we think about Dodd-Frank, and we'll talk about that later. But I know at Microsoft that there's a lot of attention and serious discussion about the risks that we compartmentalize, of compartmentalizing information rather than being more transparent and open about sharing it. So, there's some things that corporations have done, including Microsoft. We've made a real effort to kind of publicize within the company information. We share, in regular periodicals, some information gleaned from, real investigative cases. In fact, I call it, in our quarterly, there's a section called "What Were They Thinking?" and and it's consistently the most viewed section of the, they tend to skip over some of the more boring, treatises on developments and policy changes, but everybody clicks on the "What Were They Thinking?" section. It's sort of like the crime, the police blotter mentality, but it does get a lot of attention, and it's a way of sharing information, and we try to kind of tie it to certain, sometimes even seasons. It's getting to be the end of the year, so let's remind people about gift policy, and let's remind people about how some people in the company have run afoul of our gift policies by putting a story that we always make an effort to portray in a pretty amusing and entertaining fashion, even though they came from real life examples. So I think that those are examples of how you put muscle behind your program and how you help to demonstrate that. Certainly, every corporation, took notice of the Morgan Stanley result, which was that there was a decision made to prosecute just the individual and not Morgan Stanley, in part on the strength of its compliance program, and the fact that they were able to readily and easily demonstrate things like, the fact that executive who was charged, and I think he's in prison right now, for paying a bribe or soliciting bribes, that he had been trained, not just once, but 11 times, and they had the records of that. So that's another important element, is your training, your documentation of the training, being able to have a quick and ready, response that really pulls together all the pieces that your company is doing in compliance and all the different aspects, pull those together and be able to tell a good story about them and make sure that everyone in the company is aware of all of that activity.
That's great. This is one question I think that comes up a lot when it comes to FCPA, and I think the audience members, if you feel like you've heard this already too many times, please interrupt me. But I think that a lot of these FCPA matters, when we hear the details, are not very large dollars. And so there's a question of whether there should be any self-reporting done. And I wanted to see, Tracy, what your thoughts were on whether a company really should self-report, and if so, what are kind of some parameters on when it's important that they do so.
Well, we believe companies should always self-report. Look, when a company finds out that some misconduct has occurred, violations of the law have occurred, it's really their obligation to make a decision whether or not they want to self-report the conduct. I will say that that the SEC does give credit for, among, if there is a disposition down the line, among the factors that the SEC looks at when determining whether to give credit for to the company for its cooperation and for its role in the investigation, is whether they self-reported. There are 4 factors under CBORD that the Commission considers, and one of them is self-reporting the misconduct. And it's important to us for a number of reasons. By definition, the FCPA involves conduct that happens overseas. So, generally this is conduct that's gone on for a number of years. Employees have left the company. And so for us, companies have routine data destruction policies or data recycling policies, data retention policies. If a company waits to self-report, our ability to access that information is significantly diminished the longer the company waits. So if, for example, the company comes to us and says, look, we got a whistleblower who reported some misconduct. We conducted an internal investigation. It took us a year, but now here we are at your front door. Here's all the misconduct that we identified. the amount of time that's passed severely impacts our ability to either A, reach out to individuals, i.e. witnesses. Some of them may have left the company by then. Because they're in foreign countries, it's hard to track them down. Because of data retention policies, laptops have been recycled, servers have been, the information on servers no longer exists. So to us, in terms of when to self-report, the timing is critical. So the government is always going to be in favor of self-reporting the conduct as soon as possible. And if the company chooses not to self-report, again, that's the company's own decision. But if the information comes to us, and we'll talk maybe later about Dodd-Frank, if the information comes to us in a different fashion, i.e. from a whistleblower, then the fact that the company didn't self-report impacts how we perceive the company's conduct in the course of the investigation. So for example, when I talked about the 4 factors that the commission considers in the context of a disposition, one of them is self-reporting. If the information came to us from someone else because the company was diligently conducting internal investigation, to us, that's not self-reporting. So they will not get credit for self-reporting. And the fact that they come to us and say, yes, yes, we know, we've been conducting this investigation for 6 months, so now let us tell you about it. To us, that's not self-reporting. The information's already come to our attention in another method.
Thank you. Good segue to Dodd-Frank, to whistleblowers. So I wanted to put Sam and Andrew kind of on the spot and ask if you've seen an increase or decrease of whistleblower complaints really since Dodd-Frank has been put in place. And we'll start with Andrew.
I think so. I think we have seen an increase. I don't know that it's attributable to Dodd-Frank. Our team, the ethics and compliance team, has undertaken an effort to advertise our anonymous helpline, advertise the various channels through which you can report concerns or raise issues with the appropriate investigative teams. We've developed an email alias that's fairly ubiquitous around the company now that people know that they can reach out to with not just concerns but questions regarding the applicability of our code of conduct to various circumstances. We've hired outside vendors to assist us with a communications campaign in order to raise awareness of not only our team, but our code of conduct, and again, the anonymous helpline, which over time, quarter after quarter, we see an increase in usage. So I can't say that Googlers who are coding 15 hours a day are really cognizant of Dodd-Frank, and that's really motivating the increase. I'd like to think that it's the efforts that our ethics and compliance team have undertaken over the past couple of years. But we have certainly seen an increase.
Good. By the way, we just have a couple of statistics up here that are from the SEC's most recent report on the tips that they received in the last fiscal year for the SEC, which ends in September. So we can see that the high majority of them are all corporate disclosure and financials. And then there's also a fairly large number related to FCPA. And then just quickly, California seems to be the largest source out of all of the US-based ones. So there are 435 of the tips that came from California. And then lastly, when you talk about foreign tips, most of them came from the UK, with India, Canada, and China not far behind, which makes sense, I think, with the level of business interaction we have with the UK and Canada, and then obviously the level of business risk environment that exists in countries such as China and India. So Sam, maybe what are your experiences with the level of whistleblower complaints? Do you feel like it's been an increase or decrease? Or?
Right. Well, we do track, very carefully our, the information that we have about where it comes in, and we want to do that just similar to what Andrew's talking about. We want to do that so that we have some strength of the health of our reporting system. Are we getting good information? Are individuals and employees reporting things? So we separate when we look at the source of our complaints. We kind of carve out those that come from, we call them our institutional complainants, meaning people within the company whose job duties would encompass or include some responsibility, or they'd be in a position to kind of identify compliance issues. So our, our finance folks, our controls and compliance folks in the field, or our legal, our some of our lawyers or HR, those are kind of, or our regional compliance committees, those are institutional complainants. And we look at those separately from the other bucket, which are kind of our individual employee complaints. And we really want to see that number continue. Well, it's tough to say. That's one of the ironies of having a complaint investigation system. It's tough to say we want to see that number continue to grow and rise, because certainly you don't want to have additional issues reported, but nonetheless you do want to have a sense that employees are reporting issues when they find when they hear about them or think they might see an issue, and that they feel comfortable doing that. That's a really big issue. And it's a two-part one. And it's, so I haven't answered your question directly about whether we've seen an increase, because it's hard to say how you would categorize what a whistleblower is, right? I mean, we certainly track what percentage of our complaints come from anonymous complainants. We track those. We look at what our founded rate. The founded rate is the term that we use if there are any parts of an issue that has come to us that we find, yes, there were policy violations contained within that, then we say that that's a founded matter, and we count that toward what a founded rate is. And we do look at that pretty closely, and we know that our founded rate from our anonymous complainants doesn't differ significantly from a founded rate for employees who have identified themselves, and that's really significant for us. That rate, by the way, would be lower when you compare it to our institutional complainants, but you would expect that because they already have seen the information, kind of had the documentation. But whenever we talk with folks in training and we talk about people who should be reporting things, we always stress that we see that consistent, that there's a consistency between, really the legitimacy or the accuracy of the reported matters from our anonymous complainants. Because I think in the past there's been a little bit of a tendency, a little bit of eye rolling that may have gone on when anonymous complaints came in. And that's, I've been, not for Microsoft, but, in a previous role kind of running internal investigation programs for a while. And that has not at all been my experience, that people are, incentivized, that they're making complaints in order to, get money or some kind of advantage. My experience, and I think a lot of research bears it out, that in fact, making a complaint is a really difficult thing to do. Most employees agonize over it for a long time. That it's a very stressful event to them. And many, and I think, the research bears this out, most employees who do come forward say, in the past, or I hope they don't say this at Microsoft, but they've said it was a terrible experience and it wasn't worth it and I'll never do it again. And so, when we talk about, when we give our anti-retaliation training, we talk about what a relatively low adverse impact it would take to have a chilling effect on someone from reporting. And so, we say, look, that's the standard. Are you, would whatever happen to this person who reported this matter be enough to deter them, a reasonable person, from doing it again? And that's a pretty low standard when you think about it. So that's something that we stress. I haven't seen, Microsoft hasn't seen a significant uptick in its anonymous complaints, but, we'll keep tracking that and pay close attention to it.
So we have only a few minutes left before the scheduled time to end, but I think that everyone can stay for a few minutes afterwards so we can extend the Q&A. So we will probably skip the insider trading topic and the data security topic and maybe just move on to Q&A. Does that sound good? Are there any, or would you like us to cover those topics? Are there any questions? Yes?
I have a question. So, under what circumstances does a legal counsel either step into or act in a more business or strategic role regarding the organization?
You mean with respect to privilege issues or just a general day-to-day?
So I just meant more generally. So say there's M&A, some advice regarding privacy or compliance, they want to know, they sort of want to know how your knowledge of the regulatory landscape will help them make a better business decision.
Well, Sam and Andrew are probably in a better position than I am to answer that question. I mean, I think the best in-house counsel have a business sense about them, and they become ever more valuable to the company when they are able to give their legal advice in a business context, right? But
yeah, you know, I would say so. Certainly, you know, it's the notion that, you know, that they want to partner with the business to get good results. That entails not just, you know, providing strict legal advice, but also putting that into context, helping them evaluate risk. So I think that there is part of the kind of the business strategic advice that is a real value that our commercial attorneys can provide, or our M&A attorneys. I know that the compliance attorneys are far more diligent about making sure which hat we wear when we talk with the company and when we give advice. So I think that is less true and should be less true for, you know, commercial or transactional attorneys advising the company and making those kind of business decisions. It's a good question.
Yeah. Yes. Go ahead.
Just looking at that reporting, do you feel that the implementation of the UK Anti-Bribery Act has resulted in an uptick, particularly in non-governmental whistleblowing, or have you not seen any impact?
The UK. And the UK is interesting because it does have a nuance that's different from the US, where facilitating payments are not allowed, which is creates a much lower threshold, I guess, of a risk of non-compliance with it. I haven't necessarily seen an increase, but I don't know if it's been had as much attention as, I mean, it's taken many years for the FCPA in the US to get to where it is now. I mean, the law was passed in the 70s, I believe. Yeah.
yeah, I think it's hard to trace. It's hard to know, but obviously the more awareness there is in any jurisdiction, you know, the higher the whistleblowing rate, the higher the number of enforcement actions.
And I think one thing about the UK Bribery Act that's important to note is that, you know, even if it hasn't resulted in a lot of enforcement action, it's already been, I think that they would say, successful, because it's doubled the number of corporations who've self-reported since the law was enacted. And that's, you know, that's the purpose of the UK Bribery Act. It's the purpose of, you know, the FCPA, is you're trying to get, you know, governments to corporations to self-report. So in that sense, I would say it's been, you know, successful.
Data privacy seems to be an area that is in flux, and where there's different standards in the company. So you could comment on, you know, what kind of stance your companies are taking to try to deal with that?
So we take a very conservative approach to data, both data privacy and data security. And this is with respect to both employee data and user data, which would encompass our customers, our business partners, as well as a user of Google products. You know, the company takes a very proactive effort to ensure that the data is protected. There are a number of systems that the company has in place that limits access, it controls access, we audit access to user data, to corporate data, to employee data. I think that you're right, you're absolutely right. The privacy rules and privacy regulations are in flux. The company takes the most conservative position it reasonably can, in light of the capabilities of our tools, in light of the capabilities of our software.
I think from my perspective, the most interesting thing is what we're accustomed to as the kind of guidelines around data privacy in the US are very different in other countries. And there's much more protection around the data belonging to the employees in other countries than there are in the US. So from an investigations perspective, it creates a nuance or a complexity that, unless someone is experienced in that subject, could create a lot of issues with the company's foreign offices and operations.
Absolutely.
Yes.
To what extent does the SEC factor in how ubiquitous corruption or bribery is in a given country in determining whether or not to prosecute? And then from the corporate side, to what degree does that ubiquitousness of corruption factor into a company's decision whether or not to do business there? I'm thinking specifically, and this probably wasn't a major factor, may not be a factor at all, but I'm thinking specifically of Google's decision to leave China as a possible example of an area where this might happen.
You want to take it first, Tracy?
Sure. So in terms of whether to prosecute, we don't really focus on the ubiquitousness of the anti-corruption in the particular country. That may influence when we're sort of weighing risks about whether to expand our investigation and look for other areas. If we see problems in one country, for example, with respect to a company that we're investigating, maybe we ask them, where else do you do business? And if they have large operations in a country, in a particular country that is known for being a high-risk country for corruption, then we may ask the company to do some further investigation. We may request other information about their operations in that particular country. But in terms of whether or not to prosecute, we don't really look at that. It's just a matter of how we focus our resources and our investigation.
The perceived corruption risk of a particular country, in my belief, impacts very little on the decision whether to operate in that country. It certainly is an important consideration when you're designing a compliance program and analyzing what the risks are to the company in various regions. So countries like Russia, China, Japan, India, Brazil, Nigeria, we take a different approach with our compliance program in those countries in light of the notion of perceived risks of the company. Google's decision to leave China, and that's from the search functions and the search products, had very little to do with corruption in the country, but much more of a freedom of expression issue and censorship issue. Google still operates in China, still operates its ads business, AdWords and AdSense, and there's still Gmail services available. So the company hasn't completely extricated itself from China.
Did you have a question?
Yes, I would like to follow up on the data protection and privacy. When the company is going to be hacked, how often do you reach to SEC or law enforcement, federal, and reporting that to the event, and how do you mitigate it, and do you have a policy to do information sharing with other companies?
I think every panel member has something to add to that.
It's a little bit outside my area of expertise. Certainly, you can't work at Microsoft without being very aware that data security and, and protections, privacy protections, and hacking risks are very huge. I know we have giant parts of the company devoted to that very thing. We have entire units that are looking to prevent and detect and respond to any hacking incidents, but I'm afraid I can't speak with more detail to your other parts of your question.
Yeah, I mean, I think every companies have to assess the nature of the breach and determine whether approaching law enforcement is appropriate in a given case. I mean, in some instances, there might be requirements to report either to the consumers whose information has been hacked. If there are different notification statutes state by state. So there are a lot of ways that hacking incidents or data breaches will become public. And one of the things a company has to consider, depending on the scope, depending on the nature of the breach, depending on whether a breach is ongoing or whether there are ongoing risks, we'll have to consider whether to approach law enforcement. One thing that you need to keep in mind at a company before making that reporting is that once you get law enforcement involved, you may not always be in control of what happens next. So, if you do have, for example, an ongoing breach and you get law enforcement involved, they may want to not shut things down, right, so that they can try to catch the perpetrator. That may be in your company's interests. It may not be, depending on the nature of the breach, and it may not be in your customer's interests either. So there are a lot of issues that play into it. I don't know from the SEC's perspective if there's a different calculus.
No.
Okay.
I don't, yeah. I'll leave it with Sharon's comment.
Well, this is a growing problem for Google and a lot of companies.
That's correct. Well, I'll say that with respect, Google operates consistently with each state's breach notification laws. So when there is a circumstance in which there is a hack or there's compromise of our security systems and there may be some unauthorized access to data, our information security lawyers consider very carefully the circumstances of the hack, the circumstances of the intrusion, and make that legal determination with outside counsel as to whether or not that compromise in security constitutes a breach for purposes of the breach notification statutes. It's obviously something to take very seriously. When getting the decision to get law enforcement involved, we don't have a policy that says if X happens, then we refer to law enforcement. But there is an internal process by which we will send information about the compromise or about the security event to our law enforcement lawyers. So we have lawyers at Google who interact with law enforcement in various capacities. And so those lawyers, along with our information security lawyers, will make that assessment as to whether or not to refer the matter to law enforcement.
So it's pretty much policies, expose that particular hacking or not. If it's anonymous and reported, yes, to X and Y, Z report, being hacked, then people are forced to report it or acknowledgement, and sometimes they don't even acknowledge it.
Well, it depends on the type of information that's been hacked, and the state notification laws depending on the type of information, will require notification to the consumers whose private information has been compromised. There are other, if you're a public company, again, there are a lot of different things that can require disclosure. But the issue of whether to get law enforcement involved to go after the hackers, for example, that is something that will depend on the circumstances in a given case.
But that would be nice if the SEC can give immunity to the companies to release that information.
Well, there's some organizations that have been created. I know that recently President Obama, I think, spoke on this very issue, and where they're trying to reduce some of the barriers of sharing information around hacking events so that they can try to educate other companies. And then also they're trying to, I forget the term that they use, but very sensitive areas of the country's operations, so like utility companies and things like that, to allow them to share information more frequently between them. And I think in addition to that organization, whose name I can't recall, I think that there's been independently from that, there's been a couple of organizations that have been created where companies can choose to participate in it and share the details of events, and they have some parameters set up to protect the details of the information, because obviously if the hacking is about the technology of the company, which is the issue really in the Valley here, sharing that with your other companies that are part of that organization who may be your competitors is a little sensitive. So I think that they have some parameters that they've put together to try to facilitate the sharing of the information, to educate each other, but at the same time protect their data even internally. But it is a growing issue. There's been obviously lots of news about it recently. Any other questions? Right.
I have a question. Can you talk a little bit more on what course of actions would you suggest the CEO in the context of M&A transaction, in which during the due diligence phase you identify like corruption practice? So, and the CEO is saying the target's great, so we need to work around this. So, what are the possible course of actions you can pursue in this?
Sure. I mean, you know, it's the target's not so great if it's going to, as I said before, buy you a felony. So, you know, you've got to weigh that risk. But you know, if you are going to proceed with the acquisition despite finding the issues during due diligence, then you've got to remediate, right? You've got to resolve that issue so that it doesn't come back to the company post-acquisition. So you know, you do your investigation. You do a thorough investigation. If you find misconduct, you determine whether it's a systemic issue, whether policies need to be changed, you know, whether more training needs to be done, whether the compliance program in the target company is going to need to be modified. And of course, you take disciplinary action against the individuals who are involved. You've got to assess whether you know, these are one-off issues that can be remediated on a, you know, individual by individual basis, or if it's something that infects the target as a whole, in which case, as I say, it's not such a great target. And you've got to figure out how to unwind that before incorporating that target into your own company.
I think that's why boards are important, and it's important that the boards are involved in these decisions, and that you don't have an individual who might be in love with the target company kind of override the decisions. There needs to be kind of, before the idea of acquiring this company is even brought up, kind of some processes in place to evaluate a company and to communicate any of these types of issues to make sure that they're brought to the attention of the board. So the decision is made by a group of people rather than just one individual.
Correct if I'm wrong, but the way you're saying this is like you don't buy the company, right? Because if you
No.
remediate on an individual basis and you didn't buy the company, I mean, why would someone that has a problem selling the company because you disclose the problem?
Well, the remediation would only occur if the acquisition happened. So you could still buy the company, but you have to go into it with your eyes open, and you have to go in prepared to clean it up immediately. So what it comes down to is, if the person that's behind the issue is the key employee, then you really have a difficult decision to make, because the typical remediation in that scenario would be to get rid of that employee. But if he's the reason why, or she's the reason why you want to buy that company, is to get access to that person, you're in a catch-22. You can't really win.
So if I fired the employee that committed the wrongdoing, then it's fine. I don't need to disclose to the DOJ, and that's fine.
Not necessarily. As you heard Tracy say, you probably should still self-disclose, but you at least will have taken good actions to address the issue.
I mean, the issue of disclosure is a difficult one. You know, the SEC's views, you know, are one way to look at it. You know, I think, you know, every company's got to use its judgment, and there are a lot of factors that go into the self-reporting decision. But if you have a company, a target company, where there are systemic issues, you have to know that, you know, after the acquisition, at the very least, those issues are yours. So you have to handle them in the same way you would handle those issues within your own company.
And once those issues have been identified, they may not have disclosed them when you first did your due diligence because they weren't aware of it, but now they know. And they will be required, I believe, to disclose it to any other potential buyers. So there's some negotiation power that's gained by the buyer in this process. Well, I want to thank everyone. Sorry for how long we went, but thank you.